Good morning. My name is Alice Maranga, Program Officer, FIDA Kenya, and we are hosting you today to advocate for the landmark ruling on female genital mutilation court decision in the Constitutional Petition 244 of 2019, formerly Machakos High Court Petition 8 of 2017, Dr. Tatu versus Anthony Chenro, as well as FIDA Kenya and other 13 organizations. So the main aim of the webinar is firstly to engage the stakeholders from the globe, because we are being watched globally, regionally, nationally, and up to the community level, to engage with you, to understand and increase our knowledge on female genital mutilation, firstly, and also increase our knowledge on the Prohibition of FGM Act 2011, number 32. We are also allowing public to come in and ask questions on the same FGM, the ruling, and generally on FGM, what are the effects of FGM, medical, psychological, economic. FGM has so many effects around medical, psychological, economic, and social. So we'll allow the public and the people who have signed in to ask questions on that. So notably on this, we are going to look specifically on the court ruling between Dr. Tatu Kamau and the Attorney General to review Article Section 19 of the Prohibition of FGM Act, so that we can increase our scope on how the act is going to be reviewed. I welcome you all, and I request that we participate fruitfully to the webinar. Thank you.
Thank you, everybody, for joining us. We wish to hear your comments even as we go on. We have very able panelists among us who are joining us, who will be able to respond to some of the questions that we'll be posting, and the questions that, if you wish to speak, of course, raise your hand and feel free to introduce yourself and the organization as well in the chat. Thank you very much. Our first able speaker is Senior John Chigiti, who is a partner in the firm of Chigiti and Chigiti Advocate with 22 years post-admission experience. Counsel at the International Criminal Court, ICC, the African Court, a director at the Legal Resources Foundation, LRF, and certified professional mediator. Practice area family law, pro bono work, public interest litigation, and human rights cases, including intersex persons. Informal settlements and housing, marginalized and minority groups, and the rights of persons with disability, statelessness, refugees, the environment, and prisoners. He's a pro bono lawyer of the Year Awards from Amnesty International, the LSK Nairobi Lawyers Award, the Cradle, and Kituo cha Sheria. He was a lecturer at the Kenya School of Law since the year 2014 to 2019, a trial advocacy trainer and a director with the Trial Advocacy Training Institute. Offers mentorship at the Strathmore University and the Advanced Mentorship, Counseling and Mediation Limited, AMC. He's the author of the book Intersex Persons and the Law in Kenya. He's currently writing family law talks and the client and the lawyer's books. A director of the Rotary Club, plays the saxophone with the Nairobi Lawyers Music Band. I mean, we're well capable, we have a well-capable panelist among us. Thank you so much, Senior. My name is Vivian Mwendea, I'm a legal counsel at FIDA Kenya. Karibu sana Bwana Chigiti. I hope you are able to hear us loud and clear.
Yes, thank you very much.
Over to you, Senior. Kenya is a signatory to international and regional conventions. Article 5 and 6 of the Constitution expressly recognize treaties ratified by Kenya as part of our domestic law, but the treaties are subordinate to the Constitution. Some of the relevant treaties include the Universal Declaration of Human Rights, 1948, Articles 3, 5, 18, 22, and 27, the International Covenant on Economic, Social, and Cultural Rights, Article 3 and 12, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment on Punishment, The FIDA, which is the Convention on Elimination of All Forms of Discrimination Against Women, Article 125, the African Charter on Humans and People's Rights, the Banjul Charter, Articles 4, 5, 17, and 18, the Protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, that is the Maputo Protocol. Senior Chigiti, how will these provisions strengthen the review of the prohibition of the Genital Mutilation Act of 2011 to protect women and girls' rights? Senior?
Thank you very much. Indeed, a long stretch of international instruments, treaties that sit out there regionally, internationally, for you, for I, and for everybody. Specific to women, we are lucky and well-placed jurisprudence-wise because we have a constitution that is so robust, one of the best constitutions in the world, that speaks to a lot of spaces, amongst them what we see in Article 2. So that then, if we look at the specific statute that Dr. Tatu wanted to be declared a nullity, we ask ourselves, having received the judgment in the form it came, what can we do in view of Article 2 to expand, harness the opportunity, make it better for the potential victims of FGM? So indeed, all these international instruments that you have mentioned, running from the UDHR, running into the African Charter, running into the Maputo Protocol, have unique provisions which might not be very specific to what we might think they are to, but which can be embraced, interpreted, applied, tweaked here and there, so as to breathe more life into the Prohibition FGM Act of Kenya. If you look at, for instance, most of them speak to issues health, integrity of the person, protection from harm, the duty of the state to uphold the right to life, the need to create awareness, the need to protect women from discrimination, the need to speak and understand what these cultural practices are, conversations around religion. So if you read across all these statutes, instruments, one way or the other, they seek to address the concerns that the Prohibition FGM Act intended to attend to. So that the question then is, has it achieved? Is there an opportunity? Can we make it happen through broader conversations around these instruments? And the answer is yes, we can.
Thank you so much, Senior. Therefore, do you feel there is a role of the civil societies organizations in Kenya to be able to protect and strengthen the provisions of the provision of Female Genital Mutilation Act? Then what will be the role of the CSOs in your view, Senior?
Yes, indeed, the duty to protect, promote, fulfill, Articles 320, 21 of our Constitution places a huge task on the civil society organizations, including FIDA. E.g., CEDAW, we've had it, it's been around. Every other student talks about it, not even the lawyers or the judges. How much are we implementing this conversation? CEDAW is telling us protect from discrimination, harmful practices. If I looked at the CEDAW, I asked myself, if I place the protection, the FGM Act on the other side, what is it that I would want to introduce there? Indeed, we have the board under the Act. Can we say that probably we could speak in the direction of speaking the Bill of Rights through the statute specifically, so that we then speak about compensation, so that we speak about Article 23, the reliefs that are available, specifically highlight, mention them in the act. What would stop you from doing that? Look at the same act again. Why don't we have a tribunal? Is it possible to set up a tribunal like we have the HIV/AIDS tribunal to deal with this vice? Probably it needs that kind of anvil, that kind of aggressive approach, where we say probably the tribunal has powers A, B, C, D, so that the reliefs are not scattered all over the place, not known, some scattered in the Children Act, some scattered in the Penal Code. Why can't we have a tribunal which will have the authority, the mandate, to even offer reliefs which are so necessary? For instance, if you look at the protocol, it's speaking of psychological, psychosocial support, counseling. Why can't we have that conversation under one roof, so that we are not shopping in Article 2 of the Constitution for reliefs, for remedies, which could be captured if we had a tribunal, even maybe under NGEC, the National Gender Equality Commission? Why can't we maybe transfer some of those powers specifically and make them highlighted? It's FGM conversation and nothing less. And tell them, here we are, we must direct the whole village to offer psychosocial support to the victim. And again, if you look at, again, the protocol, it speaks about education, and it's a conversation that cuts across all of them. Awareness creation. Why can't we change, re-engineer the policies? Why can't we look at the TSC Act? Why can't we look at provisions, for instance, curriculum in our schools, so as to educate? Have a compulsory subject in the curriculum, right from primary school, make it compulsory, so that by the time somebody is going in the direction that we are saying is prohibited, they not only know expressly that it's prohibited, but they'll also become the supporter of the civil society organization who is going to be able to eliminate this vice once and for all. And when we talk about education, because we are speaking about possibility of legislative change. For instance, look at the Judges Training Institute. Can we take this conversation there? Can we look at what they have in form of training? Civil society organization supported by the act, because the board has that power to give you that machinery. Walk with them there. Let that conversation roll out there, so that when the matter is coming before the judges, they know the form of sanction that is appropriate for the violator. And the judges know, or the chair of the tribunal under Chapter 10 of the Constitution knows the need of the victim.
Thank you so much, Senior. Maybe just before we let you go, just for a minute, and we loop in Dr. Kimani, a question for you. Do you feel, and in your view, do you think it is a moment, it was an opportunity for Dr. Tatu's case to come and bring up the loopholes that are already existing in fighting FGM in Kenya?
Indeed, symbolically, the doctor brought the victim to the surgery bed. She brought the conversation to the court, and it's an opportunity where the judges were able to have a conversation with us, where we are able to have the AG, the DPP speak to what the act ought to speak to, so that I see the timing to be very appropriate. It is a very good timing, because we're saying we are moving towards implementing, making some of these instruments a reality, saying that we are no longer speaking a loose language of culture, consent, independence in what you want to do as an adult. We have come to a time when the best interest of the child principle has come to fore, so that it was a very well-timed petition. So that then we must ask ourselves, now that we have a judgment, what is it that we must do before another petition is filed? So that the parliamentarians can breathe life into those vacuums, speak about type 4, speak about piercing, speak about applying toxic substances on the genitalia, speak about studs, you know, the unspoken spaces which came to fore during the litigation. What are we doing about some of those spaces? Speak about the potential contradictions that the judges were pointing out in the statute, and ask ourselves, what can we do? What can we tell the parliamentarians that it is going to be done in this way or in that other way, given that we have an opportunity? Thank Dr. Tatu. I was hoping she will be one of the panelists.
Thank you, Senior. Well, she's not, but I'm sure maybe she's tuning in. Thank you so much, Senior. You really highlighted the importance also, even in your closure, the importance of post-judgment strategy. And even as we go on, those are some of the views and we'll be getting from some of the panelists as well as the people joining us. On to Dr. Samuel Kimani. I hope you're here and you're listening to us as well, even as we continue to have this discussion. Dr. Allow me to introduce you. You're a health expert, researcher, and a senior lecturer at the College of Health Sciences and African Center for Abandonment of Female Genital Mutilation, Cutting, University of Nairobi. He has over 10 years experience in biomedical and global health research. He has conducted evidence synthesis on the health impacts of FGM, designed and implemented a multi-site studies on medicalization of FGM in Kenya. He designed and implemented a diagnostic study on the health system response to FGM in Kenya and Nigeria. He provides training, capacity building, evidence, communication and advocacy for healthcare providers, researchers, policymakers, programmers, and implementers on abandonment interventions for FGM, including medicalization. He has published widely and presented in national and international meetings. Daktari, kindly, you could go ahead and unmute yourself as well as your video so that we can see you. And we have a question for you, Daktari. Dr. Tatu Kamau medical doctor petitioned and challenged the constitutionality of the Prohibition of Female Genital Mutilation Act and the anti-FGM board formed thereafter, the act and the board respectively. Does female genital mutilation have any medical benefits? Daktari?
Okay, thank you very much. Thank you for the introduction. Thank you for FIDA Kenya, and thank you for the audience for having me here. I'm excited to share some insights about this case and what revolves around FGM. As to whether FGM have any medical benefit or not, I would say it's decisively no. FGM doesn't have any medical benefit. In fact, it is the opposite. What we see in regard to FGM actually interferes. It interferes with the normal tissues, it interferes with the normal organs, and therefore it causes more harm than good. And here we are talking about whether female genital mutilation is performed by traditional kata, who are the majority who perform this practice, or whether performed by healthcare providers. And we are going to, probably that is one of the discussions that we are having here. And I would say the complications that result from FGMs revolve around the tissues that are interfered with, and more importantly, in terms of the short term. And short term, I refer to, for example, immediately the girl or the woman is cut, what happens to the tissues? Of course, you expect things like pain, you expect bleeding, you expect, for example, because of the interference with the skin, you expect infections. And then over and above that, we talk about the long-term complications. And long-term complications, a lot of people don't refer to them because most of the ladies who come to the hospital, they would not even relate these long-term complications to what happened during the FGM. So, and these long-term complications, they could also be physical, and they revolve around the gynecological, that is in regard to giving birth. They also affect the psychological aspect of it. For example, a lot of women suffer from trauma. In fact, when you start to discuss about what happened around FGM, some of them will even break down, and those we refer to as psychological complications. So in short, what I'm saying here is FGM is associated with the physical complications, it's associated with the psychological complications, and these complications can be immediate, they can be short term, or they could be long term. And all these, by the end of the day, these complications will require interventions of a health provider. And that is why health system is so important in trying to mitigate these complications and helping women and girls live a meaningful, healthy life as provided in the Constitution of Kenya. So I'll stop there in case there is more questions, then I can be able to pick it up. But the last bit that I would also say is FGM also involves girls and women who are not consenting. And most of the time they are forced through this process, and they could even have even more added complications because it is being forced on them. So they may get even other injuries that are not necessarily revolving around the external genitalia.
Thank you very much, Daktari. Maybe just an additional question. Are there medical protections that you would recommend to go into the law in regards to FGM in Kenya?
So when I looked at the case and the issues that came up, I would agree with the lawyer that there are a lot of issues that probably need to be changed, not necessarily changed, but they need to be included. And one of the things we picked up very well is the judges questioned about the omission of type 4 FGM, which according to the World Health Organization, that is also part of FGM, and it needs to be covered. And here we need to be clear, because one of the things that we know about type 4 FGM, it is when you go to some communities, what almost looks like type 4 FGM, like when you talk about the RESAC type of cutting, that is not classical, either type 1, type 2, or type 3. Sometimes you may not even be able to know whether exactly that is what type of FGM it is. And I clearly, this needs to be covered under the law so that nobody is going to abuse it. And I think this is one of the areas people can easily abuse. And there is a whole debate, for example, that people are raising, and they are saying, for example, when you talk about piercing, when you talk about burning, you introduce some cosmetic kind of issues around the genitalia. And when you look at the Western world, that is already taken like being cosmetic. But when you come to Africa, it looks like it is a type of FGM. So we need to strike a balance between those so that we don't cause more confusion. But our goal here must be, we must be able to protect women and girls. So I would say that type 4 FGM needs to be captured very well. There is an issue on what government needs to do, like captured under Section 27, that the government is supposed to, for example, raise awareness, is supposed to respond to women and girls who are having complications. I think this needs to be very clear. When we are talking about the interventions that government needs to do, we need to say that the interventions, for example, psychological intervention in terms of counseling, in terms of debriefing, all this needs to come out very clear. Because remember, most of the time, FGM may not necessarily lead to death. So what happens is already the girls who have been cut, they will live to old age. So they will live with this scar for a longer time. And every time you take data about FGM, you're going to find that these women are actually counted as part of the statistics. So we need to capture this and make sure that, for example, interventions that revolve resolve issues to do with these complications are well covered. Of course, when you look at the mandate of the health system is two things. One is prevention of any diseases, and number two is care and management of any diseases. So for us as a health care system, we need to respond through providing care, and this care must be very well be streamlined, and it needs to capture, even take care of women and girls who have gone through FGM. I know, for example, immediately the cutting has taken place in terms of first aid and stabilization of the patient. That happens, but this needs to be captured very well. So I think those are some of the things that needs to be captured under the review. The judges, of course, they were questioning what is the relationship between FGM and mental issues. And I think that one cannot be debated. Once you go through FGM, through physical cutting, it has mental repercussions. And these mental repercussions need to be addressed through mental health approaches, including counseling, including psychosocial support. And this is what needs to be anchored in the health system so that women and girls can be able to benefit. And mark you, this is one of the areas, even in our research, we have realized it's a largely neglected areas. So you go to a health facility and ask whatever the nurses, the doctors, and everybody else, what do you do when a woman comes because they are having psychosocial complications associated with FGM? Most of the time they will tell you, we try to apply the general counseling rules, which for me may not necessarily be very effective. So we need to see, in a way, how do we become more focused in responding to these critical areas of health that are associated with FGM. Thank you.
Thank you, Daktari. And you've brought up a question of the mental issues and the concerns that come about with FGM. And as we were speaking to Senior Chigiti, in terms of the role of the CSOs in fighting FGM in Kenya, we spoke about some of the roles that the CSOs have, and indeed he highlighted they really do have a role in terms of advocacy, among many other issues. But as you've brought out the issues of the mental concern that it brings about, then that also brings about the role of the CSO in terms of ensuring that there's that targeted form of psychosocial support to victims of FGM. Thank you so much, Daktari. Maybe before we let you go, do you know of any, or do you think of any medical practitioners who are practicing FGM in Kenya?
Thank you for that question. I think that falls under medicalization. There is we use the term medicalization. Medicalization means that the FGM is being performed either in the hospital, in a neutral place, at home, by medical practitioners, not necessarily medical doctors. It could be medical doctors, nurses, midwives, clinical officer. So when that happens, then we call that medicalization. We know that is happening. Actually, the hotspot in this country is actually in the wider Kisii County. You find this in Kisii County in fact, it's the highest. For example, if you ask people in Kisii County, how many girls have been cut in the last maybe 1 year, they tell you, I know 10. Then you ask the second question, whom do you know cut these girls? They will tell you 8 out of 10 are actually cut by healthcare providers. So the statistics are very shocking in Kisii. But not only in Kisii, we are finding this again, it is also moving. We have started to see this in Narok, in Kajiado, in Nairobi, and also in Garissa. Those I can mark as hotspot areas for medicalization. And of course, the bigger percentage is by the midwives and nurses. And then we have a smaller percentage by the doctors and the clinical officers. Now, one more thing I should be able to mention, the act is a bit silent, is actually silent on clinical officers. And that is one of the recommendations that I'm actually giving, that we need to include the role of clinical officers to be covered by this act, because there are actually a lot of them, and they are the ones who are providing services in the primary level health facilities. That is the dispensary, the health centers, and the dispensaries. So we need to make sure that we include clinical officers, because they are regulated by the Clinical Officer Act, Cap 260, and they are practicing in this country. And we know they run clinics, they run health facilities, and those facilities could be used for the cutting of girls and women in this country. So they need to be covered. If the act is silent, then we are doing injustice to the women and girls in this country. Over to you.
Thank you, Daktari. So we let you go meanwhile, but I invite my other moderator, Florence Machio, who is a tender activist, and she'll take over from here, from Vivian, to invite Carol and the rest of the panelists. Thank you.
Thank you.
First of all, thank you very much, Daktari. I know Alice has told you you can now go, but don't go. Stay around. Stay around because there's some questions that will be meant for you from the chat, but also just to say, as I thank FIDA for putting this together, to remind all of us that have joined, thank you so much for joining us. Write your question. There's a Q&A tab on your computer or your mobile device. Click on it, write a question. All the panelists will be able to see the question and respond to it. Some questions might need for them to voice the answer. Some they will respond on the chat. So if you have a question as they're speaking, kindly do that so that we ensure that your questions are all answered. And Daktari has started on has talked to us about the medical effects of FGM. And we all know that, especially those of us who are activists, as Alice has said, given that in the beginning we pushed for the act to be there, now it is there, and now we are looking at how do we strengthen it and make it better. So I want to introduce Caroline Ncharo. Caroline is an assistant chief in the area of BC location. She's a survivor of FGM. She's a crusader and campaigner against female genital mutilation and child marriage. She's testified during the Dr. Tatu Kamau versus Attorney General female genital mutilation case, the case that we are discussing today. And I would like her to just, give us her experience. And I know that Caroline, if you're there, if you can hear me, just unmute so that we are together. And so Caroline, I'd like to ask you, the doctor has already told us some of the effects, but based on your experience, what are the effects that FGM has on women and girls? Of course, your position as a chief, you're also able to see some of these cases. So not just your personal experience.
Through my personal experience, FGM first, wakati unapotairiwa, it's so painful. Unakatwa, the clitoris, which you know very well, according to the doctor, I'm not a doctor, but ikona a lot of soft tissues. So you unakatwa and no any medical inatumiwa pale in our time, unakatwa tuna wembe. So it's so painful and you lose a lot of blood. Secondly, during wakati wa kujifungua, there is a lot of complication. You know, you are dealing with a dead body. So maybe the tissues or the venye, wakati wa kujifungua, uzazi venye itapanuka, it has a lot of, it take a lot. That's why unakuta, for these ladies when you wametairiwa, wakona prolonged labors. Psychologically, it really affects you. Kwa sababu, first of all, ukienda na watu, when people start to discuss about FGM, na ubaya wote wa FGM, you always know that I'm among the team, wale wametairiwa maybe imepitia pale. So psychologically, inaku affect sana. Okay, another thing about FGM, what I'm experiencing now, pale kwa ground, it's a twin sister to teenage pregnancy. Because our culture, when a girl is circumcised, it seems she's ready to move on, and they take her as a woman. That is why we are getting like 13-year-old child being pregnant to 16 to 17. Then we go to primary school, from class 6 to secondary. Almost every girl has a child in school, or maybe wale wameza wakaolewa. So it's a twin sister because of the cultural practices, or maybe how the culture believe that once you are circumcised, you are a woman.
Thank you very much. Na asante sana kwa kutupa, historia yako ambayo kwa kweli ni chungu. And then for those who are watching us and, some of the, her response, some of it was in Swahili because we have international audience. She was narrating how painful the experience was, its connection to also, challenges during delivery, when you're giving birth. But also, I think for me, it raises the question of, and I think Daktari, maybe you can answer it at some point, that could we then link this? Do we have enough evidence to link FGM to maternal mortality as one of those causes? Do we have evidence to link that, especially in those communities that practice FGM? So Daktari, if you can at some point, you'll answer that question. But back to you, Caroline, ningependa kujua kwamba wewe ungependelea vipi tutie, how do I put it? How would you like us to strengthen in English? Yes, okay. How would you like us to strengthen the FGM, Anti-FGM Act, especially around other harmful practices? Because you've said it is a precursor to child marriage, it's a precursor to teenage pregnancy. How do we help you being a chief? How do we make sure that this law is stronger enough so that these other things are also prevented and other harmful practices?
Okay, to me, I say the law is a bit silent when it goes to court. And this is where we are facing a lot of challenges. You arrest somebody and you arrest the circumciser to the court. The first thing you are being asked in the court is about the evidence. So have you caught her with a razor or a knife? And maybe that time you have just linked the circumciser through the child who circumcised. And the child said, this is the woman who has circumcised me. So going to court, the first thing you will be asked is it's about the evidence, and maybe you didn't collect the evidence. As you know, the investigation are not done by chiefs, maybe it's done by police. Second thing, when it comes to the law, it takes long, maybe to arrest, maybe kotini sema itachukua muda kumjudge yule mtu, to take time. So maybe akiwa out pale ametairi watoto wengine. So at least, if possible, let the law ikue a bit strength ili iweze kuadhibu the violators. Secondly, you arrest the parents, but pale utaona tu ameenda katoka. Why? And the child still amesuffer, ameshakatwa kwa sababu that's nasema tu evidence, bado utaambua tu evidence, nani alimuona, ulikuwa pale. So such questions or such nini most of the time zina azisaidi. Ukipeleka mtu polisi uone ametoka hajajajiwa, you feel like maybe haujasaidika. So a bit the law is silent hapo, itiwe mkazo.
Thank you very much. Do you mind repeating your last point, please? Just your last point. Yeah.
Okay, I'm trying to say how the law is a bit how the law is a bit silent when it comes to court, when taking the circumcisers, or maybe the parents who have circumcised their girl. You see, if you don't have an evidence, then you lose the case. Second thing is, after taking the girl to the court, nothing follows. It's you, the person who have rescued that child, to take responsibility for that child, to get a counseling, or maybe it's violating the right of that child. It's you to get how the child will stay. You see, it will overburden you.
Thank you so much. I think that's
any other point. Circumcision is still going, though they are doing in a secretive way, but it is still going on.
All right. So despite the law, FGM is still continuing. And you've raised a very valid point there, that when you take up the case in terms of supporting the victim, in this case, a child, you know, with the whole process, maybe the parents have been arrested, the circumciser has been arrested, then the burden is left on mostly CSO, you know, CSOs to take care of this child. Yet we have the children's, you know, we have children officers, we have all that department. How do we link all this in terms of supporting survivors? So thank you so very much, Caroline. And I want to, because we have many panelists, I just wanted us to get a feel of each of the panelists, and then all the questions you have, we'll ask. But Caroline, we'll come back to you again. So thank you so much for being present. I want to also introduce Emily. Karibu sana, Emily. Emily is a litigation and research counsel at Katiba Institute, where she undertakes public interest litigation on socioeconomic rights, in indigenous peoples and community land rights, and women's rights. So this is a person after my own heart. She has previously worked as a law research clerk at the Supreme Court of Kenya and the Constitutional Court of South Africa, and also is in academia as a researcher and lecturer at the University of Pretoria and Africa Nazarene University, respectively. Emily, karibu sana. As we try to get Emily back, I want to introduce Christine. Christine Congo is a vibrant, self-driven, highly motivated and astute advocate with a passion in constitutional law, human rights, law, and legal writing and legislative drafting. She's a graduate of University of Nairobi and had advanced her studies in international relations. She's an advocate of the High Court of Kenya with 15 years post-admission experience. In the year 2010, we need to note that Christine Congo decided to pursue her interest in women's rights and joined the Federation of Women Lawyers as a legal counsel under the Access to Justice program. She later joined the Kenya School of Law as a lecturer. She's currently serving as a senior lecturer and the course coordinator of legal writing and legislative drafting under the Advocates Training Program. She's also the editor-in-chief of the KSL Justice newsletter. She has facilitated several trainings under family law, policy, legislative drafting within Kenya School of Law, FIDA Kenya, and IMLO. So Christine, I know I have not finished your bio, but I hope the summary has covered who you are for now.
For now. Yes.
Yes, I realized in this life you might start having, when you start explaining who a person is, you might not finish. We might end here, but thank you so much for giving us your time. I have a few questions for you. Dr. Tatu claimed that the FGM Act 2011 violates women's rights as per the Constitution of Kenya 2010. The Constitution entrenches respect for human rights, the achievement of equality, and the advancement of human rights and freedom as its foundational values. Article 28 provides for the right to inherent dignity and the right to have that dignity respected and protected. You being the lead counsel on this case, where is the disconnect in the implementation of the Constitution and the enforcement of the Act?
Thank you very much, Florence. First and foremost, may I just say that I was very honored to have represented FIDA Kenya, where I serve as a board member in this matter. And I'm happy to have seen two of my colleagues who are also the lead counsels in their respective rights, Senior Chigiti and Emily. Now, I just want to start by saying that I believe that there is really no disconnect, and I think the judges pronounce themselves quite well in this matter. And I just want to reiterate that this act actually reaffirms the Constitution. And if I may take you through the history of this act, having done this matter we were in court from 2017. Florence and Alice. So it's good again to just go to the history in terms of these issues. So this particular act was the brainchild of KEWOPA, Kenya Women Parliamentary Association, who I represented as a 6th interested party in this suit together with FIDA. But looking at it in terms of where did the rain start beating us in terms of FGM matters, we can clearly see that this was a bill that was sponsored by KEWOPA through Honorable Fred Kapondi, who I believe is still an MP. And one of the things that they intended to address is that as a stakeholder in the FGM issues, they saw that indeed there were very many gaps. At that particular moment in 2011, when this bill was passed, you could see that there was a gap in terms of there were 2 statutes that were able to be used by stakeholders and people who were fighting FGM like FIDA. That was the Children's Act and the Penal Code. But still, we had various gaps. So the Act was meant to address these gaps. And we also had a national policy. At that particular point, there was a policy called National Policy for the Abandonment of FGM that was developed by the then Ministry of Gender in 2010. But still, we are still seeing the cases of FGM rising every single day in this country. And through KEWOPA and through Honorable Fred Kapondi, they brought this to the House and they were able to convince their colleagues that we must have a proper legislative framework through the Prohibition of FGM 2011. Now, towards that, if you look at the preamble of this act, and you know the preamble is a very important element in matters statute. The preamble says that this act was meant to prohibit the practice of FGM and safeguard against the violation of, number 1, a person's health and physical integrity through the practice of FGM and for connected purposes. You realize some of our panelists today, like Dr. Samuel Kimani, have already talked about the issues regarding health and physical integrity, which are some of the effects of FGM. Now you see, towards that, what I'm getting to is that Parliament exercised its power, its legislative mandate, to ensure that they had a proper act, which will then deal with some of the gaps that you are seeing 2011, before this act was then passed in Parliament. And we can say that they achieved their mandate because this act, and the learned judges pronounced themselves very clearly, was meant to protect, promote, and respect women and girls who are victims of FGM. So I think I want to quickly say that the act doesn't bring out a disconnect between the act and the Constitution. If anything, I think Parliament did the best thing through KEWOPA, and you can also see that at that particular point, and even now, there was a state obligation to ensure that the state had to exercise its obligation under the Constitution through Articles 2, Sub-Article 5, and Sub-Article 6, and also through international conventions to ensure that we have a proper legislative framework to deal with harmful cultural practices. So I can safely say that indeed this act was thought of very carefully, and even at the particular point in which judgment was read in March, the 3 judges agreed with all of us who are trying to ensure that the act does not go away. Now, leading to that, in terms of just looking at if indeed there's a disconnect, may I say that perhaps the disconnect only comes in terms of implementing or in terms of enforcing this particular act. And you can see Section 19 again comes to play in terms of Type 4. Type 4, which was unfortunately omitted in this particular act. If you read that judgment delivered in March, I believe one of the judges picked it. Honorable Kanye Kimondo picked it and said that even the current MP, Honorable Millie Mabona, at that particular point in 2011, tried to talk about the fact that Type 4 needs to be classified. But may I say at this particular point, members of Parliament, in their wisdom, at that particular point, decided to leave it out. But here we are now, 6 months after the judgment, the judges have said, we need to go back to the act, and this particular Section 19 needs to be looked into so that we can classify Type 4 FGM. Now, may I also say in terms of implementing this act, I believe this is one of the challenges that we are having in implementing this act, because we need to be very sure, number one, what can fall under type 4. So classification has to be very specific. So practices like cosmetic surgery, for example, piercing of the genitalia, you know, and all other beauty decorations that an adult woman would want to do to the genitalia have been left out. And that's what Dr. Tatu was trying to argue, that is in the act not trying to discriminate, so that if today, Alice Maranka, you try to beautify your genitalia, are you not FGM, or what is the difference? But you see, of course, it has not been classified in this particular act. So then that's the challenge. Right. Section 19 has to be reviewed. I think that's what I can say at this particular point.
Thank you so much. I think Alice is laughing and thinking, oh my goodness, we never thought about that.
Thank you, Christina. So 4 of FGM is recognized, but as much it's missing in the act, which needs review and to be incorporated, because there are those types of FGM like having rings around your genitalia. That's a form of FGM. Trying to pull it, it's a form of FGM, but it's not covered in this particular act, which we need to look at. Thank you, Christine.
Thank you, Christine. I see there's additional conversation on what else needs to be described as FGM. And maybe I want to go back to Daktari. So I had a question. The question to me was, so that we don't forget it, and then we'll go to Emily, the issue of, are we able to medically link some maternal mortality to FGM, given the challenges that women who've undergone the CAT go through during delivery?
There is no data to show there is a linkage between maternal, or whatever, FGM and maternal mortality. And the mortality here, we are talking about deaths for a good reason, because FGM being illegal in this country, even reporting is an issue. It's very difficult for people to report that somebody has been cut, even to report that somebody has died out of cut. But anecdotal evidence that is not documented shows that actually FGM can result to death from bleeding, from complications like infection, stuff like that. In fact, a classical case was in 2013. New York Times actually captured one of the, in our neighboring country, Egypt. A girl died in 2013 because of FGM. And this is of interest because that girl had been performed FGM by a medical doctor. In fact, in Egypt, 70% of FGM are performed by medical doctors. So she died despite that this FGM was performed by a medical doctor. So you can already infer from there what happens in FGM that are performed by traditional cutters. More girls are likely even to die, and especially when you are talking about more severe types of FGM, right, type 2 and type 3. So what we know for now, and the classical and elegant studies that were conducted by WHO in 2006 that are quite well referenced, they documented the relationship between FGM and maternal outcomes. And maternal outcomes here were things like a woman who had been performed FGM was likely to go through cesarean section. A woman who had been performed FGM was likely to develop tears on the external genitalia. They were likely to bleed more. They were likely to have more bleeding from giving birth. That evidence is there. And that is some of my colleagues, Professor Jaldesa, who was an expert witness in the Tatu Kamau case, actually participated in that study, and they were able to identify those complications. So what we know is there is evidence that poor maternal outcomes are associated with FGM. In communities where FGM is performed, we have what we call poor health statistics. And these health statistics revolve around mothers getting sicker, dying out of childbirth. and also children who are also dying out of that. So that is already there, but to pinpoint how many are dying out of FGM, it is difficult to say.
All right, thank you so much, Dr. Thank you. I think for me, I'm now thinking through and thinking, what more evidence do we need to gather so that we are able to make a stronger case in strengthening this act. Now, Emily, I think you can now hear us. So yes, for me, it's given your experience, and I wanted to pick up, I think when you went off, I was picking up on something that Caroline, the FGM survivor who is here in our panel, mentioned on the issue of the rights of that child who, the parents have been, taken to court. The perpetrator is in court in terms of the circumciser. And now the child is usually either the burden, quote unquote, of a civil society organization, because sometimes the children officer will only go a certain mile and tell you, where else do you put this child, or find a place to put this child. What are the rights of this child, and how do we reinforce them if we were to go further in strengthening this particular act?
I think in terms of strengthening the act, we consider issues of the physical health of the child, especially if they've undergone the act. So that is very crucial for them to get treatment as soon as possible to help them. Secondly, also is psychosocial support, which is very critical for the child, because as the case had stated, a lot of the witnesses came to court and provided evidence of the psychological effects they suffered way after the FGMC was performed on them. So it's also very crucial and in the best interest of the child for them to get psychosocial support from there. So I think those ones are very critical, and also safety. We find that most of this or performing of FGM is usually in a cultural context, predominantly in Kenya, and also in the family setting. So I think organizations and the government needs to be creative in terms of having secure homes or places where these children can be put in place as maybe the court process is taking place, or even after that, because you might throw them from the frying pan into the fire. Because as it was stated by Carol, this FGM is it's a twin to other cultural practices. So they will be exposed to issues of early childhood marriages, early childbirth as well. So all this, you need to protect it and cut it at the bud, like right when it's starting. So these are some of the considerations that I think both the government as well as other organizations who are working with children need to consider.
Yeah, so one of the objectives of this conversation was also looking at, overarching the thing is supporting safe spaces for girls and young women to challenge female genital mutilation. And we've just come from the sidelines of generation equality, where Kenya has made commitments and put, some huge sums of money. We don't know which one goes where, but would this be one of the conversations? How government gives you, we have given this amount, but there's no breakdown of what this amount is about to do. Looking at the fact that these survivors need safe spaces, would you say that this is where one of the things that we should do as civil society organizations should do in terms of pushing for certain monies to go to certain things, especially safe spaces, considering what I know survivors have gone through and lack a place for safety? Just your opinion.
Yes, I think if organizations can champion for safe spaces, these safe spaces, I think looking at maybe the government resources or what they have put in place, it could be safe spaces maybe to cater generally for different issues, but at least to cater for the rights and the needs of the child. They can stay there, but then other services can also be provided for the child. I think also what is crucial in terms of the current funding at this point in time that we need to consider about is linked to the judgment and what the court said. So the court had given orders to the Attorney General that they need to, if I may read it, that the Attorney General shall forward proposals to the National Assembly to consider amendments to Section 19 of the Prohibition of Female Genital Mutilation Act with a view of prohibiting all harmful practices of FGM as set out in this judgment. So I think currently that is also a key consideration in terms of funding. So there needs to be support that is offered to the Attorney General because this is a very technical issue. The case had quite a number of experts. We had experts from the medical profession because they also tackle issues of mental health and the link between mental health and FGM. Maybe to the court, they might not see a link between mental health and FGM, but to a mental health professional, a psychiatrist or a qualified psychologist, might know other issues of FGM. For example, people who want to undergo gender reassignment because of psychological issues. Will that then flow into issues of FGM? So the state cannot close its eyes to that. So there needs to be funding in order to sustain that so that whatever proposals are taken to Parliament, they are strong enough and they're solid enough to also cover future eventualities. Working as well with the DPP, working with communities in the ground. The DPP especially because this case, when looking at that specific proposal to the Attorney General, looked at the issue of criminalization of FGM and there being a lack of a process for enforcement if you cannot classify or establish or investigate the 4 types of FGM. So the DPP has to be part of this process. Medical health practitioners, OBGYNs, they need to be part of this process. People from civil society, all of them also need to be part of this process. So we need to think holistically and strategically. Where are we putting the funds? If it's safe homes, yes, we can do that. If it's funding to support or funding being directed to the Attorney General to ensure that whatever amendments are sent to the Parliament are solid, I think that is also very critical.
Perfect. So thank you, Emily. You've been answering a question I wanted to ask, even with your response, which is great. But then for me would be, because I was going to ask you, who do we need to target? You've already raised that. So for me, it's to ask then, among all these people, where do we start? Where do you think we should start? In the Attorney General's office? Where do you think we should start?
The order is targeted, the court order is targeted to the Attorney General. So, but I think also the anti-FGM board will be part of this process, whatever they'll be looking at moving forward. Professionals, maybe representatives from the like physical health profession in terms of medical doctors, OBGYNs. And then the second field also would be I would target mental health professionals specifically because we cannot ignore that. And it was mentioned in paragraph 116 of the judgment. So it needs to look at the whole of Section 19 holistically and look at some of the pointers that were put across. And then finally, you have to look at the DPP. Not finally, but part of the people you have to look at is the DPP, the Director of Public Prosecutions. So for these charge sheets as well to be proper and to be sound so that we don't have any gaps in terms of criminal law on effective enforcement, I think that is critical. Also, in terms of medical health ethics and working with a DPP, who exactly goes to investigate and see what type of FGM has been undertaken? It definitely cannot be the police. So maybe forensics, Department of Forensics that work closely with the police. That is very crucial if they're going to collect specific evidence in terms of FGM practices, or even the medical health professions who work with the police for establishing the crimes. Yes, I think those ones are key. And organizations, we cannot leave aside or put aside organizations that work closely with the communities, community-based organizations, and also the people. I think the critical thing about the people, it might come later on when the amendments are taking place through public participation, but there's also no problem of it coming at this stage if suggestions are offered, but there will still be room for public participation. So there needs to be monitoring of the process of when the amendments are tabled before Parliament and bill tracking of the bill so that you are able to know the first reading is on this day, the second reading is on whichever day. So when the time comes for you to do public participation, you actually turn up for public participation. Kenyans always cry public participation, but I can assure you 10 or 5% of you have ever attended a public participation meeting, if we are honest. Yes, so very few of you have been able to attend and ask the questions, so or read whatever has been put forth. So that is also an encouragement to those working in the sector to keep an eye on that.
All right. Thank you very much, Emily. I just want to remind everybody who is on this webinar, kindly indicate your question in the chat. There's a Q&A chat box. Indicate your question so that we can read them out to the panelists. They can respond to them. There's a question here. Well, Caroline, we will link you up. So there's somebody who wants to do an interview with you. So I'm assuming that's a journalist. Then there's somebody who's asking, policies can be strengthened well enough. The only challenge with most of the policies is effective implementation. We need to align issues on FGM to specific intervention for effective address. This should include, for example, intentional efforts to include FGM practitioners in such conversation. I'm not sure when you say FGM practitioners, what exactly you mean. Do you mean the cutters? What do you mean? And so maybe as I scroll through and see where the questions are, I would like to go back to Senior Counsel John Chigiti. You had elaborated very well as after when you're linking us, with the international instruments, and also looking at the conversation around awareness creation. We are in the process of, you even mentioned curriculum, looking at the curriculum, our current curriculum, and making it compulsory education in relation to FGM. We are grappling with CBC, some of us CBC parents. So we have had a struggle in this country just allowing sex education in school. I don't know how this would be packaged so that it is palatable to those that are against appropriate sex education in school, especially when you talk about FGM. Your thoughts, please.
Thank you very much. Indeed, the board has a mandate to generate policies, to come up with programs, and that space is unlimited. All they need to do is generate conversations that will speak to the direction of the curriculum that they intend to roll out. Go to the curriculum setters, go to the Ministry of Education, go to the Honorable Attorney General. As we propose these amendments that we are discussing, let that be part of it. What will stop that from happening? Nothing. So then it becomes part of the course outline. Right from very early, when the child is even 10, 12, they start interacting with this conversation so that we stop children hearing from the roadside about FGM. Let them get into the conversation, into the dialogue very early. So the state owes the duty to inform, to educate, and those policies, away even from the board policy and program level, can be informed from the Bill of Rights conversation, from the Article 53, from the Article 43 level, so that when we are speaking with so much authority, Bill of Rights driven. And once we are able to pump the conversation in the curriculum, we must then also go to the conversations around the teacher the TSC, how much they know. Some of them interact very closely. Most of the cases are discovered by the teachers. How much do the teachers know? In the teachers training institutes, do we have this conversation going? Then I was also thinking probably we also need to rope in paralegals. Most of these NGOs, civil society organizations have paralegals. They are the grassroots. How much do they know about FGM? That is a task that can be embraced. The civil society organizations can get supported, funded in their programs by the state. Talk about the Legal Aid Act. We have pro bono lawyers. We have entries which are eligible to legal representation under the Act. Can we tailor make it? Can we modify it to specifically mention FGM cases as cases that are eligible to legal aid services? And in that direction, I'm speaking to cases of compensation. I don't know, FIDA, have you filed any case in the Human Rights Division seeking compensation for Caroline, for instance?
Okay,
I don't know.
We've had cases on public interest litigation, and we've done not specifically filing a case, but one memorable case I remember of a campaign which we did and was very successful. It was for Jedida. Jedida is a girl who died in Meru some 3 years ago, and she died out of FGM. She had been cut, but because of the culture of that place, the ethnic culture of that place, Jedida was taken to the forest to heal there because she used to stay with the sister, and the culture doesn't allow women who have children and they are not cut to continue staying in the homestead. But unfortunately, she caught up with pneumonia, she died. We did a campaign together with the Churincheke. Actually, it was very successful. Jedida was given a dignified burial within the homestead because they are not supposed to be buried within the homestead, but she was given that dignified burial within the homestead. And we raised a monument within the Churincheke shrine, which even you go there today, you'll be able to see that shrine, which says, Jedida died of FGM, apart from that she died of pneumonia because the doctor justified that Jedida had been cut and she died of pneumonia because of that FGM. And it's a campaign which we need to move on with. And FIDA Kenya has many other public interest litigation cases, but FGM senior Chikiti, as you've mentioned, is an area which we need to have a public interest litigation, and more so with our own Carol, because even the people who are watching us, they want media, they want to interview Carol. The people who are watching us also want this story of Carol to be taken up by FIDA Kenya, which I think the management will humbly honor and try to defend women and children through the experience of Caro, our assistant chief. Thank you, Senior.
Thank you very much. I'm happy to hear that that is happening. Caro, you can hear you're the candle bearer. And I believe these are conversations that must devolve. It doesn't belong to the village.
That's true.
It's usually from Nairobi downwards. This time around, it's happening in the village at a grassroots level. So let's have cases in all the 47 counties and get declarations where we'll be able to hammer the FGM through the hammer of the judge. Thank you.
Thank you very much, Senior Counsel. Let me look at the questions. There are some, I think there's an additional question in the chat. I am waiting. Yes. So girls and women with disabilities are still at high risk of FGM because they're not able to run away for their dear lives. How can the social societies, community gatekeepers, e.g. chief Nyumba Kumi initiative be in high alert to help them? Jemima, this question, I think I want to address it to Caroline, having been experienced, she's a chief, but also I think I will also rephrase it for Emily. So girls and women with disabilities are still at high risk of FGM because they are not able to run away for their dear lives. How can the social societies, community gatekeepers, e.g. Chief Nyumba Kumi initiative be in high alert to help them? So any one of you, Caroline, you could go first, or Emily, whoever is able to. Carol, can you hear me? Having the fact that Caroline, you're an assistant chief, you have experience, how do you stay on high alert so that you're able to know which home state is going to carry out an FGM act, and then you're able to mitigate before things go out of hand?
About the disabled children getting FGM?
Yes, and just the fact that, you know, even the girls, women and girls with disabilities, of course, are at high risk. They may not be able to run away from home. How do you maintain high alert to be able to know either this home something is happening, or, you know, to just be able to arrest the issue before it goes out of hand?
We use the village elders. We call them the balozi wa nyumba kumi kumi. At least at every 10 houses, the balozi must know that there is a child. She's a disabled child, and she keeps an eye to the child. So that's the way we are protecting. And also the most of these disabled children, like in Kajiado, we have Kajiado Child Care Center. Most of them are there. But when they come home, their parents secretively, they do FGM to these children. But most of the time, we keep an eye to them through the Nyumba Kumi initiative.
All right, thank you very much, Caroline. Emily, I was interested in you in terms of, you know, given your broad experience, what needs to happen? I know in this country, we are not challenged in terms of laws, but we are constantly challenged in terms of implementation. How do we support women and girls with disabilities, especially on this matter? What's the government mandate, so to speak, in ensuring protection for these very vulnerable ones?
I think if you look first, if we start from the Constitution Article 52, where special care has to be given to specific groups because of the position they've been placed, you will find that children now falling under Article 53, then on top of that, they're girls, that now falls under 56, and on top of that, they're further disabled. So the duty of the state is even more in terms of the measures and the duty to protect this child against third parties from interfering with a child. So in this particular instance, the state has to come up with, I think, processes or policies or a way of undertaking. And when I say the state, that also includes the anti-FGM board. Remember, they're there. So what are the means or mechanisms they can use working together with communities? Because I think every Kenyan has to realize the duty to respect rights is on everyone. It's not just the government. It's both on the government as well as individuals. And then secondly, for the state, they have a further duty, the positive obligations they have to ensure that they protect this vulnerable child, who's also a minority, from further violations of her rights, especially undergoing FGM. They can come with policies, they can come up with programs, they can come up with plans of maybe mapping out which are the areas where maybe these children are and what are the ways in which they can be protected. I think at the end of the day, when it comes to implementation, what Caroline has said, working with chiefs on the ground, I prefer like we say on the ground, things are different. I think I have more preference to maybe seeing how to work directly with those who are on the ground, the chiefs, or those who have been, county policing is supposed to be it should be now at the county level. It's not happening, but that's one key area in which we can see further protection of the rights of these girls who are physically disabled. But I think it's also just a general protection. The fact that they are from communities that highly practice FGM, there should be a lookout or a watch out during the seasons when FGM is taking place, so that all girls are protected and those with disabilities are further protected. Because if you take maybe all of them to a school during the season or a safe house, it's everyone, whether they have a disability or not. So it's just looking holistically at measures on which you can protect them.
All right, thank you so much, Emily. There's a question again for Caroline. Caroline, I hope you're still with us. The question says, would you say that civil society organizations have been successful in contributing meaningfully towards FGM eradication? So Caroline, since you are on the ground, and Emily has just said on the ground things are different, would you tell us, you being their chief, you're more to the ground than any of us, would you say that civil society organization, mashirika ya kijamii, have been successful in contributing meaningful towards FGM eradication? Caroline?
I say at a percentage of 75% they have contributed, but these remaining 25%, I think there is a failure because most of the meetings are done in urban centers without reaching the grassroots level where there is this thing, in urban centers, FGM is a bit going down, but there is those points. There are some organizations which are working well, they are down there, but in some points, there are some places which are unreachable. Maybe getting the sensitization to them, it's a bit far from them. That's why I say it's not 100% sure. It's not, I can't give it 100%, but.
Okay. So you've already actually answered the other question, which was, in your opinion, what would they do differently? And you've mentioned that some of those meetings are in urban areas. I want to ask Christine, my question to you would be just in connection with what this viewer has asked, where does the mandate lie? Because sometimes I feel being in the civil society organization, it is expected that the civil society organization should educate the public. Where does the mandate lie in terms of providing information and educating the masses? Where does the mandate lie?
Okay, thank you, Matthew, for that. I think it's not lost for all of us that we seem to have a role to play, all of us. And when I say all of us, I mean civil society organizations like FIDA Kenya. Like we also feel that the government, through even its 3 arms of government, have a role. And you can see this is one of those matters whereby I can say that the 3 arms of government have played a role. By coming up with an act, the legislature has played its role through KEWOPA, the Women Parliamentary Association. Then we can say that in terms of the executive, they also played a role in terms of coming up with a policy. But it's true, the policy had gaps and the policy was not able to be implemented well, and that's what led to the coming up with the statute. But you can quickly say that the executive came up with the policy, it played its role. When it comes to the other stakeholders, like the civil society, we can see that many are taking this issue very seriously in the last 20 years or so. But sometimes we have duplicity in the CSO. We also have our own political wars. Everyone wants to do what the other one is doing. So I believe that there's need to collaborate further post this judgment as to if you feel you are best to handle these matters within the community, let the NGOs that are working within the community do their job. If you feel you're well placed to work with Parliament, then we allow you and we give you that safe space to work with Parliament. If you feel that you can go out there and create awareness still about this act, because believe me, not everyone is aware in this country that we even have an act. Not everyone is aware that there is what we call the FGM offenses. to date. So there's still a lot of room for creating awareness. So I believe that we can all play a role, but let us concentrate on our focus areas and let's not duplicate each other's work. Let it not be one of those issues within the civil society sector whereby you are either going to do what someone else has done just because you know donors will then see what you're doing, or you also want to have a say. Let's play our role, but collaborate and coordinate. So to come back to your question, and pursuant to the judgment, all eyes are now on the Attorney General. But as CSO, we cannot wait for the Attorney General anymore. We also must initiate this discussion. And I believe this webinar is the beginning of that discussion. After this webinar, we should now see the CSOs working around FGM, bringing us together either in a forum like, some sort of a conference or a meeting with the AG, with the DPP, with any other relevant government organ to start the discussions on how do we then review Section 19 of the Prohibition of FGM Act. But I believe this is a fight that no one can win on their own. The government will not be able to do it if you see they have a lot of challenges. They rely on CSOs. We are CSOs, we cannot win alone. We must work with the government. So we all need each other. And that is a fact, and facts don't lie.
It's true, Christine, facts don't lie. Now, there's this other fact that exists. Most counties that they have communities that practice FGM are coming up with anti-FGM drafts. Now, how do we then now influence, and this can be taken by any of the panelists, how do we stop or rather ensure that the things we're discussing here are part of those county anti-FGM acts that are in the process of being made? I understand Taita Taveta is working on one, so I don't know whether Migori is working on one or any other county, West Pokot. How do we then ensure this conversation influences those discussions at county level around FGM?
Thank you, Florence. Maybe I can say that, number one, it's a good thing that we are now having legislation, the process of legislation devolving to the counties, because this is where we also want the Constitution, 11 years down the line, to be able to allow us to be able to have such county legislation. Yes, we have a national legislation, and we are now aware there's 1 or 2 gaps. But the fact that now counties are taking the initiative, I think it's very timely. But I know from experience working in the legislative drafting aspect, we have challenges within county sessions in terms of drafting, sometimes the quality of law, and I mean this with all the respect, the quality of law coming from counties sometimes have a lot of issues. It is not the same quality like we have within the national laws, because we know the AG is now involved in drafting, but when it comes to the counties, we've seen there's a bit of challenge because the legislative drafters are not many and are not as qualified or are not as specialized like what we have in the national level. Now, I would then call upon again the stakeholders, some who are attending this forum. We are able to work within the county legislative departments to be able to help them come up with appropriate county legislation in terms of anti-FGM. So again, time is right, but you realize that all this needs a bit of coordination. All this may require funding, which some counties are struggling with. So then, what Emily was saying earlier, funding is now one of those things we need to look at as CSOs. Who can we rely on to help us so that we work together with county governments to come up with quality legislation anti-FGM? Because indeed it's true, once we have proper county legislation within the 47 counties, then this will also be helpful towards implementation. But remember, the challenges there are, we're still struggling with county legislation in this country. So then they need help, and we must be there for them when they call upon us to do so.
Sorry,
Kimani, you wanted to
jump
chime
in
in?
a bit. Yes.
Okay, please go ahead.
Yeah, over and above what Christine has said, I think one of the weakness about the Prohibition Act is people still say, including the anti-FGM board, they say it is more centralized and it doesn't speak to the devolved government. And I think some of the things that we should be thinking is, how do we then devolve the anti-FGM functions, or how can we then include the devolved governance into the anti-FGM board, so that it can be more responsive to the needs of the counties. I know that has been a big debate. For example, when you talk about the anti-FGM board, there should be a representative from the Ministry of Health. But when you look at the Ministry of Health functions, most of them are devolved except the policy issues and the standards and the tools development, which are held at the national government. So there is need to think of the composition again, and probably maybe we think about that. But specifically, even to come to what you are saying, what most of the counties are actually doing is actually to cascade the prohibition of FGM board and the national and the policy against FGM that has been developed by the anti-FGM board, by maybe coming up with what you call anti-FGM steering committee. Of course, the question would be, how effective are they? I know the steering committee is actually headed by the county commissioner, and all the stakeholders are members of that, including the health and also the CSOs. Yeah. The second thing that I've also seen other counties like Migori and Kisii do is actually developing what you call costed action plans. Costed action plans, they do actually help to anchor FGM into the county activities, so that you anchor anti-FGM programs into the county activities and budget for it, and you can actually be able to intervene. And then finally, even come up with things like what you call other tools, like minimum packages, which can actually be able to respond to prevention, management, and care of the girls and women who have FGM. I think with those tools, then we can actually be able to operationalize the anti-FGM law. And the last bit, I think, is the issue of awareness is a big thing. Whether you are talking about awareness across professionals, whether you're talking about awareness across the communities and all the stakeholders, people don't know much about prohibition of FGM. And I think that should be the starting point, because when I look at the way we are going, of course, the judgment has been made. We need to review the section 19, which is important, but that can actually override all the other important things, because when people have not even started implementing it, and you're already thinking of reviewing, then we are actually almost like jumping the ship. So we need to move these processes all together very well, start sensitizing people, including healthcare providers. And healthcare providers, yeah, it is important. We need to bring in the regulatory bodies, medical board, nursing council, clinic officer council, so that this issue of medicalization stop. Because when you talk about the judgment that was given, when you look at that section 19, it actually touches on issues that healthcare providers are actually doing, and they are not supposed to be doing, basically because they don't understand the law itself. So I agree, we have a long way to go, but I think this is a good discussion we have started, and we must be able to continue expanding the participants and the audience, so that we can move together. Thank you.
Thank you very much. And Dr. you brought in a very interesting aspect that, yes, while we could end up focusing on one particular aspect and forget the other things that need to happen for this law to make sense to Kenyans, including creating awareness. But then how do we, as we review what the ruling said that needs to be reviewed, how do we ensure the other aspects of the law are being implemented even as we speak? Because then this case gave us a spotlight into the Anti-FGM Act, and then it also gave us a spotlight for people to realize there's actually this act that exists. Did we use that time well to publicize the law? Or how best now moving forward do we then strengthen the other areas that don't necessarily need review? How do we go ahead with that aspect?
If I jump in very quickly, I could, for example, tell you, yes. In 2020, that is the year we started seriously engaging the healthcare professionals in the discourse of FGM. and addressing FGM in this country. And the issue that has been there is all the other actors, all the other stakeholders have been ahead in addressing FGM in this country. But what has been lagging behind is actually the ministry, the health sector. And we said this because when we look at medicalization, it has been actually increasing more than decreasing, whereas the rest of FGM is actually decreasing. So we started this discourse, and in last year by around September, we were able even to bring in the Minister of Health, and the Minister of Health was able to issue a policy statement against medicalization. And that is where the discourse started. Of course, that was a good thing. From there, a lot has happened. One of the things that have happened is actually developing of tools and training materials to build the capacity for healthcare providers. So what I'm trying to say here is we need to make sure that awareness creation is actually a priority, especially among what you call the duty bearers. Once the duty bearers become serious in addressing FGM, then things are going to be even easier on the ground, even moving the rest of the agenda of this country. Because remember, we also have the target of 2022. The president has already issued the decree that by 2022, new FGMs must end by 2022. So all the sectors actually are actually being mobilized, resource-wise and otherwise, to try and be able to respond to this presidential decree by 2022 to end FGM. So we should ride on this very high political commitment and the goodwill by the government and also the donors and everybody else. In fact, right now, as we say, a lot of communities are already committing. When the president committed himself to 2022 ending FGM, a lot of commitment from community leaders and also religious leaders came into play. They actually said we are also going to be together with the president to end this practice. So as professionals, as stakeholders, as CSO, we should also take advantage of this environment so that we can be able to move everything, including the modifying and reviewing the law and also addressing any other gap that has been identified in the address of FGM in this country.
Just a quick follow-up to what Dr. has said. May I also say, in terms of what Dr. has said, that for other duty bearers, I think they're also picking up this conversation very critically. For example, the Office of the DPP has now set up a department, a very department that is concentrating, its only focus is anti-FGM prosecution. So you can see there's goodwill even among duty bearers like DPP. So that department is now able to specialize on prosecution of FGM. They keep on sensitizing their officers within the DPP. But may I also say, in terms of, so that we don't lose the focus and only concentrate on Section 19, time is also ripe for us to keep on training law enforcement officers who also prosecute these matters. And also it's safe to say that political will is there, right from the President of the Republic. But sometimes we don't have political will among the enforcement officers like chiefs. I know Caroline is here, but we, as FIDA, we've said that sometimes chiefs are also part and parcel who encourage FGM to still happen, so that during the day, they preach one thing. At night, they encourage other people. Particularly now that we're going for elections, it is not lost that there are some politicians who preach that FGM must end during the day. In the evening, they actually are the people who are colluding with other people to still practice this because they believe that is the only way they're going to get votes. So again, we need to be real in this country that we cannot preach something during the day and at night we are doing the opposite. So political will is there from the top, but I don't think it's devolving to where we want it to devolve. Thanks.
Thank you, Christine. So we don't have devolved political will. That's quite interesting because you brought in 2022 election and Dr. also brought in the fact that the president committed himself and said by 2022 we'll eradicate FGM. And I am cognizant of the fact that there are many politicians who will not open their mouths when they go back to the village. They might open in the parliament and hopefully not be quoted, but they wouldn't want their constituents to know that they don't they don't support FGM. Now, given where we are lying right now, 2021, 2022 is our election year. We have a few months to election. We are looking at section 19 that needs to be reviewed, right? We are, and then we are looking at, we have not enforced this Prohibition of Female Genital Mutilation Act 2011 at all in the way it should have been implemented. Given the scenario we are in, we have a deadline with this FGM, it has to end. We have to review section 19. And then we have an election coming up. Do you think Attorney General will be in the mood of having this discussion? Where do we start? So I want each panelist to just give me their thoughts. These are those random thoughts you have and asking yourself, okay, what will be possible, what will not be possible? So kindly, each of the panelists, whoever is ready, maybe I start with you, Emily. If you could start.
Thank you. Thank you, Florence. On my part, I think I would say, let's push and wait and see what, there were no timelines in the judgment. Ordinarily, we would hope there's timelines, for example, filing a report by the Attorney General within 90 days or within 6 months, then that would have given us an idea upon which at least they would be given time to prepare and come up with whatever they need to come up. Because it's also amending laws, you have to be cognizant of the fact that there might be a new parliament, so you could be changing parliament when the law is being taken to be amended. So those are some of the considerations we can consider. But between now and August, it's less, just slightly less than a year. I think it's possible. It could be possible because it's a slight amendment, just one provision. So I think if that push comes in terms of maybe a committee being formed and assisting in terms of coming up with what the provision should read, then that will assist and the amendments could be faster than that. Yeah.
Thank you, Emily. So my question to all of you is, where do we go from here? Given where we are, election is coming. That means even if we start engaging any specific parliamentary committee in terms of our conversation, those guys might not be back. And then given that we have a deadline, 2022, based on what the president committed himself, that we will eradicate FGM by 2022. So all hands on deck. But as Christine has said, not all politicians' hands are on deck. Where do we go from here?
My boss, Mr. President, just said that 2022 FGM will end. But still, I'm trying to figure out or thinking about my community. Little one. So about the Parliament, either the outgoing or the incoming, let us try to engage a lot women from pastoralist community who are in leadership so that they can push this thing because they know they are victims, they are survivors. So let us try to bring them on board. Thanks a lot.
I'll go to Dr. Kimani. Your thoughts, where we find ourselves?
Yeah.
Given political timelines and everything else being considered.
Very well. You are able to hear me?
Yes.
So what I would say is, I think as stakeholders, the electoral process is there, and it is a process as it is. And the FGM, of course, addressing FGM is also a process. What I would say is most of us as whatever stakeholders, we are duty bearers, we are professionals, and I think there will be retro interference from the politics. So we need to do what we can do as professionals, make sure that we fine tune the issues that we need to be captured in the act, and then of course engaging other gears in terms of the other stakeholders like the policymakers and the parliamentarians. I'm aware the anti-FGM board, I think we can leverage on the strong goodwill that we have, especially we have Honorable JP Kiribon there as the CAS. We have a very vibrant anti-FGM CEO those are people we can already start to engage so that they can also engage the politician. But I think moving from there, from here, I see like the medical board, the medical professions, they have a greater role, especially to define what type 4 FGM is and what needs to come in. So we need to start moving. And the good thing is between now and November, we still have a window. I think the heated politics will start in November going forward. So we still have like 2 months to play with, which we can do the table work. And then we start to do the running and bringing on board the politician. So I'm optimistic, and especially with the president, I think that commitment is there. He can always be able to whip his members of parliament to come and amend this because of the passion he has for the protection and care of girls and women in this country. So let's leverage on that goodwill. Thank you.
Thank you very much. I wanted the final word from everybody to respond to that question. And if we don't have senior counsel, we can, I think, get to a close. Yes, because we have run a good time. And I want to thank you so much for being an engaging audience. I thank you for our panelists for, just being open to be present for these hours that we've had here, to interrogate the, the judgment, to look at what are the possibilities. And I don't think this is the end of this conversation. We even have a few things that FIDA Kenya has been asked to do.
Thank you.
So thank you so much. Over to you, Alice.
Yes. Thank you, Florence. Thank you, the people who have signed in to listen to us. Thank you, panelists. On behalf of FIDA Kenya, I just want to thank all of you for the good work, for the good deliberations. Just to bring us up to speed, we've discussed many other issues apart from Section 19 of the Prohibition of FGM Act 2011, one of them being curriculum. And I can promise you, FIDA, we've already started working with the Churches Institute. We've already done our survey in some 5 focus counties where we work with our partner, UNFPA, that is Baringo, Samburu, Narok, West Pokot, and Elgeyo Marakwet. And soon we'll be launching this report on what are the findings, especially what will go into the curriculum of the churches. We are working with the University of Nairobi on TBV on the same issues, knowing that FGM is part of TBV and cultural practices. And also FIDA Kenya, we are largely working on public interest litigation. And one of the proposals is that we need to take up a public interest litigation on FGM. From the people who signed in, the issues coming up that there is cross-border FGM, which we need to look at as we review this Prohibition of FGM Act. We have already realized that we need to do thorough awareness at all levels, international. FIDA, we are able to do that awareness at the international, regional, national, and local level, because we have that status as a premier women rights organization. So we'll be able to do that. We've also realized that there are matching areas that are coming up in FGM, especially type 4 of FGM, which is not covered in the legislation currently, which we need to take up, and many other gaps, and also coming up with a board regulating the FGM Act at the national level and at the local level. I'm happy that some of the people who signed in, they have already informed us that there is Taita Taveta who have devolved down the anti-FGM bill. They are working on it and it's at the assembly. And as we were discussing, we were looking at our timeline. If we are not able to do it at the national level to end FGM by 2022, as the president already declared, Emily informed us that it's not yet done. There are new governments coming in and they'll pick it up from there, because on reviewing this act, we are not given a time limit. So we are going to research And most of the issues we were looking at is psychosocial support is a major one, mental health is a major one, which is completely almost missing out in this, which we can bring in. Economic also, it's there, but that's restitution, but still, how can we make it better so that it can work for the women and girls? Maybe we are talking about children, but let me inform you that women also are going through a lot of FGM, and they're even going into the forest, cutting themselves because of the culture, our culture in different ethnic groups. Some of our participants who are on, they raise an issue that let's not look at it completely per se the same way, because it's different in different areas, in different contexts. So those are the areas we are going to look at, especially like now we see Kisii, it's medicalized, and you may not be able to know, as Dr. Kimani said. So we are going to have it wholly looked at from different perspectives as we move on. And I promise this is the first of our webinar, but we'll be having more and more webinars coming up as we continue researching and looking at other areas that we are able to review. And thank you so much, partners who supported this. Thank you, our panelists. And we look forward to contacting you next and more other partners to come in and share the experiences. Thank you so much on behalf of FIDA Kenya.